George Brandis has been in the federal parliament as a senator from Queensland since May 2000. From Sydney originally, he attended Villanova College in Brisbane and then the University of Queensland, where he received a Bachelor of Arts and a Bachelor of Laws with first-class honours. Following his graduation, he served as Associate to Justice Sheehan at the Queensland Supreme Court. He was then elected a Commonwealth Scholar and obtained a Bachelor of Civil Law from Magdalen College at Oxford. He was called to the bar in 1985 and appointed Senior Counsel in 2006. And since they brought back QCs in Queensland, he's come back as a QC. So I'm not sure if any of the other states have done this, but certainly Queensland has. In early 2007, he was appointed Minister for the Arts and Sport in the Howard government, and after the loss of government by the Coalition later that year, he became Shadow Attorney-General and is currently also Shadow Minister for the Arts and Deputy Leader of the Opposition in the Senate. His outspoken advocacy for press freedom and freedom of speech more generally places him centrally in the Liberal tradition, and I'm delighted he is with us today. And this is what the title of his talk is going to be, Where the Human Rights Debate Went Wrong. Please welcome Senator Brandis.
Well, thank you very much indeed, Greg. It's such a pleasure to be here, and I want to start by apologising for the fact that a few weeks ago I had to cancel my previously scheduled appointment to make these remarks, but I'm sure with the vicissitudes of the election campaign you will understand and forgive. I want to as well begin by acknowledging the work of the Centre for Independent Studies for some, I think it is 37 years now, as Australia's preeminent liberal democratic think tank and centre of intellectual excellence. And your own work, Greg, you have been, this is your creature. I know that you were the inspirer of this in your garage, I think it was, all those years ago. And you, through this institution and personally, have led the debate about ideas. It has always frustrated me that for so long commentators have said that the intellectual action in Australia is on the left, when so much of the intellectual action in Australia, so much of the shape of modern Australia has been the result of creative thinking among those who subscribe to the liberal democratic and the conservative traditions, and has been led by institutions such as yours. Now, as Greg said, I've called this talk, I'm not going to read from scripted remarks, but because frankly I've been too busy in the election campaign to write a long speech, for which perhaps you'll be relieved. But I have decided to call these remarks Where the Human Rights Debate Went Wrong. And what I want to talk about is the relationship between freedom and human rights, and how in the last 20 or more years there has been a very deliberate, conscious and methodical attempt by intellectuals and political leaders of the left to marginalise freedom from the centre of the human rights debate and to appropriate to the ideologies of the left the language of the human rights debate. In the event that the coalition government wins office on Saturday week, and I were to be the Attorney-General and indeed Minister for the Arts, it would be one of my first priorities to re-centre that debate where it should be, with freedom at its very core. I want to take you back, not quite 6 months ago, to a very important 24 hours in the history of freedom in Australia. That 24 hours started at about 11 a.m. on Wednesday the 20th of March, and it went through till about 10 a.m. the following day, Thursday the 21st of March. The first of those timelines I've chosen was the time at which the Attorney-General Mark Dreyfus announced that the government was abandoning Nicola Roxon's bizarrely entitled Human Rights and Equal Opportunity Bill. That was the bill that would have imposed unprecedented restrictions and limitations on political discourse in Australia. Dreyfus's announced abandonment of the bill was a great victory for our side of politics. Not quite 24 hours later, Senator Stephen Conroy announced that the government wouldn't be proceeding with the creation of the Kafkaesque public interest media advocate, an officer whose powers would have subjected the Australian press to a regime more invasive than anything Australia had ever seen before in peacetime, for which the closest precedent was the attempt by Governor Darling to license newspapers in the colony of New South Wales in 1825. It was a great 24 hours in the history of freedom in Australia. It went almost entirely unremarked because you will recall, I'm sure, that 24 hours culminated a couple of hours later with Simon Crean's spectacular press conference in which he tried to bring the whole show down, and eventually, after a period of weeks, he succeeded. But the question I want to pose is, how did we get to that stage in this country? That simultaneously an elected government thought that it could get away with imposing a regime of social engineering on our country, which sanctioned overtly attempts to limit freedom of political discourse, and at the same time to impose unprecedented limitations on freedom of the press. There is a coda to that observation. Last Monday I debated Mr Dreyfus at the Financial Review's Attorney-General's debate. It's so obscure as the Attorney-General's portfolio that that debate doesn't occur at the National Press Club. It occurred at a Sydney law firm. In the course of that debate, Mr Dreyfus, I'm sorry to say, announced that were the Labor Party to be re-elected, it would reintroduce the Nicola Roxon legislation. So that's yet another reason why the stakes on Saturday week are so high. I think the debate about freedom of speech in this country today crystallised for many people in September of the year before last, when Justice Bromberg of the Federal Court gave his decision in the Bolt case. That, I think, was the moment when the freedom of speech debate left the university common rooms and the law school tutorial rooms and made its way into the RSL clubs and the front bars of the local pubs. That was the moment at which Australians, not necessarily people who are particularly interested in politics or follow it closely, realised that we had laws in our country which would enable a citizen to be prosecuted for expressing an opinion which the ordinary punters, I'm sure, thought was a fair point to make. And if Andrew Bolt could be prosecuted for expressing nothing more than a political opinion about whether a certain group was entitled to receive a certain welfare, to be the beneficiaries of a certain welfare program, if it could happen to him, it could happen to anyone. And I believe that since the Bolt case was decided almost 2 years ago, the debate about freedom of speech, freedom of the press, the liberty of everyday citizens to think and say what they like in a free society has been a subterranean issue in our polity. Not, of course, as prominent as the great issues of this election campaign, such as debt and waste and economic mismanagement and loss of control of our borders, but important nevertheless. And if there is anything that is emblematic of this period of Labor government beyond its sheer incompetence, it has been its appetite for social engineering, its appetite for the government, through its agencies, and, in the two instances I've given, actually through legislation, to boss everyday citizens around and tell them that what they may think and what they may say. The spirit that informs this government, as I wrote in The Spectator recently, is not the spirit of Voltaire, it is the spirit of Robespierre. And yet, paradoxically, at the same time, we have had more discussion about human rights in Australia than I can remember at any previous time. That discussion about human rights has been largely a discussion about the rights of refugees, or people claiming to be refugees. Or it has been a discussion about the rights of gay people, particularly in the context of the gay marriage debate, or a discussion about the rights of certain other minority groups who claim the privileged status of victimhood. What strikes me as bizarre is that the debate about freedom of speech and the debate about human rights have been conducted as if they were in parallel universes. The only point of intersection between the two has been those of the left who have actually invoked human rights principles, as they would define them, to limit freedom of speech, to limit freedom of expression. It is time, and this will be my personal mission if I have the opportunity to do so, to reposition freedom at the heart of the human rights debate. And that starts by acknowledging that there is no human right more central than the freedom of the individual and all of the freedoms that go with it. Freedom of speech, freedom of expression, intellectual freedom, freedom of religion, freedom of association. But before I go on to talk about what I want to do were I to have the opportunity to achieve that end, I want to pose the question, which is posed by the topic of my talk. How did we get to this point? Where did the human rights debate go so wrong in this country that freedom, the great Enlightenment ideal which inspired modern liberalism, that freedom was marginalised from the very heart and soul of that debate? I think there are two answers to that question, and I want to talk to you about them briefly. We got to this position as a result of the combined effect, in the first place, of a changing attitude to freedom by the parties of the left, and at the same time, a failure by the parties of the centre-right, the failure of the liberal democratic tradition to defend their own heritage. Let me deal first with the changing attitude of the left. Until relatively recently, the left used the language of liberty. Not economic liberty, of course, but certainly civil and social liberty. The reforms of the post-war period aimed at liberating certain social groups were expressed in libertarian language, most famously women's liberation. Following the Wolfenden reporters half a century ago, gay liberation. The left was a critic of censorship and it wanted to free information. Censorship was regarded as a conservative instinct. The left argued for greater freedom of access to information and to other material. What I think has happened in the last 20 or more years, and I think it is one of the most important intellectual developments of our age, is that large elements of the left have abandoned their liberalising instincts. And that has led to two important shifts in the thinking of the left. The first of them has been a redefinition and a narrowing of human rights. We were brought up to believe that human rights were the great rights acknowledged by the Enlightenment, enshrined in the great instruments like the Declaration of Independence and in the great canonical texts of liberalism. But within our generation, the human rights debate, the very meaning of human rights, has been shifted. I was taught at Oxford by one of the principal avatars of that movement, Professor Ronald Dworkin, who died only earlier this year. Dworkin published a very famous book, it's probably in Paddy McGuinness's library here, called Taking Rights Seriously. And he argued for a rights-based approach to public policy issues. He was the author of the famous catchphrase, "Rights are trumps." And most of the jurisprudence of the 70s and the 80s and the 90s, starting with John Rawls, and Dworkin and Ackerman and other principally American writers, was a rights-based jurisprudence. But in the course of that jurisprudence, the definition of rights was subtly changed. For Dworkin, the fundamental right was what he called the right to equal concern and respect. The right to equal concern and respect. Now just reflect on the implications of so recasting our notions of the most fundamental rights in those terms. This is way beyond an equal protection clause type right. Way beyond the idea of equality before the law or civic equality, principles to which I'm sure everyone in this room would wholeheartedly subscribe. The right to equal concern and respect, let me dwell particularly on the last part of that, and respect, means the elevation of a privileged status, particularly associated with those who claim to be disrespected, in other words, who claim to be victims, which prevails over other rights, particularly liberal rights. And what it does, to use a term very commonly used by the left, it privileges certain rights over, in particular, egalitarian rights over traditional liberal rights, traditional civic rights. That is a profoundly important intellectual development, and we see its fingerprints in the debate that we have had in Australia in the last 2 years, particularly over the Roxon anti-discrimination bill. The rationale for the infamous prohibition on conduct that offends or insults, not expressed very elegantly always, but if you drill down, the rationale was that a person's freedom to express an opinion will always or should always yield to another person's right not to be offended. Because by locating as the irreducible minimum of human rights discourse the right to respect, you necessarily attenuate every form of libertarian right that can be characterised as being disrespectful. Imagine the abridgment of political and social, legitimate political and social discussion that involves. The abandonment by the left of its commitment, or at least the commitment of the democratic left, large sections of the democratic left, to liberal values, libertarian values, which within our lifetimes they proudly avowed, was bad enough. But there was a second technique adopted by the left as well. The left well understood the intimate connection between language and thought. It was a lesson that many writers, most famously I suppose in the 20th century, George Orwell, taught us in 1984 when he invented the word thought crime. He understood, and the left learned his lesson, that if you control that which people might say, you control that which people might think. There is an inextricable relationship between thought and discourse. It is no coincidence, by the way, that one of the great avatars of the modern left, Noam Chomsky, began his career as a professor of linguistics whose path-breaking work as a scholar was in exploring the relationship between language and the cognitive structures of the brain. George Orwell gave us the word thought crime, but when Senator Nick Bolkus introduced the Racial Discrimination Act, and particularly Section 18 capital C of the Racial Discrimination Act into the Senate in 1995, quite oblivious to the origins of the word he was using, he said that Section 18C was designed to prohibit speech crime. There is no, you can see it in the Hansard, there is no distance at all between speech crime and thought crime. And so if you control what people may say, you control what people may think. And because of that insight on the left, of those on the left, freedom of speech went beyond being a value that had been displaced from the centre of the rights debate. It actually became an obstacle to the prosecution of the left's conception of human rights. And so it became not merely acceptable, but in the eyes of many, desirable, so to attenuate and, in appropriate cases, prohibit the expression of language, because language is a window on the mind, and if we control what people might say, as I said a moment ago, we control what people might think. So the attack on freedom of speech isn't bad enough, though it is best understood as an attack on intellectual freedom itself. That agenda has been adopted by so many of the institutions who traditionally one would have thought would have the defence of intellectual freedom woven into their very DNA. And let us start with universities. Let us start with universities. We all know so many egregious examples, including, shamefully, in this city at its oldest university, of universities no longer being bastions of intellectual freedom, but in which intellectual freedom is actually under attack as a bad value. From universities, let us go to the profession of journalism. Now, there are some very eminent journalists here, and they obviously know that I'm not including them in my remarks. But where were working journalists, with honourable exceptions, in the debate about the public interest media advocate? Where were they? Where was the self-appointed arbiter of community, including journalistic standards, the ABC, and the Media Watch program, at a time when press freedom in Australia was under unprecedented attack? Well, I'll tell you where they were. They were assuming the role of apologists, if not cheerleaders. And lastly, where was the very institution created by the Parliament and funded by the taxpayer, whose brief was to protect human rights in this country, the Australian Human Rights Commission? Not only was it missing in action during that debate, it was actually acting in violation of its own statutory obligation under Section 11 of its Act to advocate and uphold the principles of the United Nations Covenant on Civil and Political Rights, which by Article 19 declares freedom of speech, freedom of expression, and freedom of the press to be fundamental rights. When I tackled the new chair of the Australian Human Rights Commission, Professor Gillian Triggs, on this issue in Senate estimates in February of this year, her answer was revealing. I said, where were you? Talking about freedom, because under your Act you're obliged to uphold the Charter, and the Charter doesn't prioritise between what we might call egalitarian rights and libertarian rights. You've got to uphold all of these rights. Where were you? And she said, if I may paraphrase her, we were involved in the debate, Senator, but we were more concerned to point out the limitations of freedom. I said there are two reasons, or two ways in which the human rights debate has gone wrong. One has been the seizure by the left of the language of human rights, the marginalisation, and in some cases the actual depreciation of the value of freedom of expression for ideological purposes. But there's another reason why the human rights debate went wrong too. Because people who subscribe to the liberal democratic tradition vacated the field. We let the left take over the language of human rights. We abandoned, and I see this in some of my colleagues to be honest, we abandoned human rights as if it were a left-wing cause. Now, how can it be that at the end of a century in which there were more people killed in the name of the ideological causes of the left than in any century in human history before, how can it be that at the end of a century that saw the embrace by the authoritarian left of murder on an industrial scale as a political and ideological method, how can it be that we, on our side of politics, abandoned human rights as a cause of the left? But some, not all, some did it. We have to re-embrace the human rights debate, but remind people that we in the Liberal Party are the party of human rights. As I'm fond of saying in parliamentary speeches, there is only one party represented in the Australian Parliament that was created for the very purpose of respecting and upholding and defending the rights of the individual. And that is the Liberal Party. That's why it is called the Liberal Party. The Labor Party was created to advance class interest. The National Party, or the Country Party, was created to advance sectoral interest. The Greens were initially created, at least, to prosecute a particular series of proposals from an ideological point of view vaguely related to the environment. And increasingly vaguely related to the environment. But there is only one political party ever established in Australia that was actually set up to defend human rights. Because for me, human rights and the rights of the individual are synonymous. And that is our party. What we have to do is we have to re-embrace that agenda on our terms. And we do that by repositioning freedom where it should be, as it was to those who inspired us, the great philosophers and scholars of the Enlightenment. We have to re-embrace what we might call a Jeffersonian view of human rights and make that argument an argument on our territory. Let me conclude by telling you three specific things that, if there is a change of government on Saturday week, within my portfolio, I mean to do. First of all, we will amend the Racial Discrimination Act by repealing from it the provisions under which Andrew Bolt was prosecuted. Secondly, we will, by gentle encouragement, if possible, by statutory amendment if necessary, retask the Human Rights Commission to pay at least as much attention to liberal democratic values as its existing act actually requires it to do, as it does to anti-discrimination law and what I've called egalitarian values. And thirdly, I want to address what I call the secret assault on human rights, which has passed under the radar screen, unnoticed, and for which, in varying degrees, both sides of politics are culpable. And that is the routine limitation and abrogation of traditional procedural rights and privileges in Commonwealth statutes, so that today measures which reverse the onus of proof, which impose strict liability, which remove privileges such as the privilege against self-incrimination or lawyer-client privilege, or which delegate to the minister a regulation-making power which is an abdication of the responsibility of the Parliament to legislate. Statutes of that character, containing provisions of that kind, are now almost routine. I'm sorry to say that both sides of politics have been responsible for it, but vastly more so in the last 6 years. There has been a greater assault on human rights in this country by legislation of that kind, barely noticed, but presenting as it does an attack on human rights and the rule of law, two concepts which are themselves inextricably linked, than there has been in all of the conduct, in all of the executive action of which refugee lawyers or gay rights advocates or various other self-appointed human rights custodians complain. That is what we are going to do. That is at least what I am going to try to do. I want to seize back the human rights agenda, bring it back to where it ought to have been, because there are no more important human rights than the values of liberal democracy, and the only political party that can be trusted with them is ours. Thank you very much.